Next case up is State of Ohio versus Ralph Infante. This is case number 2019-T-0043. I believe counsel for both sides are present, correct?
Correct.
So each of you will have 15 minutes to present your oral argument to the court. The appellant may reserve up to 5 minutes for rebuttal. Just let me know how much time you're reserving so I can remind you if you get close to that. The court does record the argument, so we ask that you stay at the podium, keep your voice up so we get a good recording. Although this is the 11th district case, isn't it? Correct? Mm-hmm. So there will not be a recording of this. The 11th district does not record their arguments. Only the Summit County 9th district, Summit County, Medina, Lorraine, and Wayne 9th district does record. So you both know that there will not be a recording available. At any rate, you should not use the names of children, minors, or victims. Use initials if you plan on mentioning any of those. We've read the briefs and we are prepared to proceed if you are. Attorney Governor. Will you be reserving time?
Yes, Your Honor. 3 minutes, please.
3 minutes. I'll let you know if you get close. Also, of course, we have it up on the television screen there. All right, you may begin. Thank you.
Thank you. Yes, good afternoon, Your Honors. I am David Doughton for the appellant Ralph Infante. This morning I'd like to address 2 issues. The first one being the enterprise issue, whether there's sufficiency for a RICO enterprise here. Given time, I would also like to address the 4th assignment, which is the forensic auditor who was, whether she was properly determined to be a lay witness instead of an expert, and the ramification of her ability to give an opinion based on being a lay expert. To begin, the issue with the enterprise is we have to determine, this court has to determine whether this is a series of violations by Mr. Infante or whether this was a RICO conspiracy. You know, obviously every defendant who commits a series of violations is not also automatically part of a conspiracy, let alone a RICO conspiracy. And what is lacking in this case is there was no enterprise. That the offenses to which he was convicted were all personal, were all things that he essentially did by himself and frankly didn't need the assistance of anyone else, and there's no evidence that they were. And I'm talking about, you know, tampering with records, most of which were failing to provide accurate information as to taxes or having received money that he wasn't reported, you know, unlawful interest in a public office, and most of all the gambling offenses. And to be an enterprise, it's key in this case is that it has to be an ongoing organization. It doesn't have to be formal, but it has to be an ongoing organization. There has to be a longevity of time with associates that function, and this is with a continuing unit. In other words, this can't be a case where, you know, A helps him, you know, give false reports. I'm not saying that's the evidence here. B helps him, you know, run the gambling. C helps him with another matter. It has to be a continuing unit, and this is also key in this case. And the structure of that unit has to be separate and apart from the activities that creates the pattern of criminal activity. In other words, if, for instance, and I'm not saying these are the facts, but just hypothetically, if he had somebody with the blocks with the gambling, and that person took the money for the gambling for his once-a-year Super Bowl party, if the only association that Mr. Infante had with that person was the gambling, that's not an enterprise. That's not an enterprise. The Ohio law, which is based on the federal law, is very clear that the enterprise has to be separate and apart from the criminal activity alone. And so that creates a problem here, because in this case, it's, you know, there two, you know, just to be a pattern of corrupt activity, and again, the indictment indicated association by fact, 2 or more incidents related to the same enterprise. Again, there's no enterprise, but all the incidents are isolated. We have a pattern of and Mr. Infante testified. Well, you didn't report this. You didn't report to us your income tax until 2015. You did. Okay, those are individual violations of which he could be convicted of and was for tampering with records and stuff. But the mere, and the Ohio Supreme Court has indicated this in Schlosser, it's been the law since 1979, merely because an individual engages in a series of activities which the prosecutor believes has violated an ordinance or a law, the mere fact that it's a series is not a violation of the RICO statute.
Counsel, does it make a difference, and I'm not saying all of the allegations fell under his being mayor, but does it make a difference that at least a number or a series of them fell under the guise of Mr. Infante as mayor?
No, I don't think it makes a difference because as mayor, again, the legislature set out theft in office, violation of public, there are individuals to cover that. The fact that as a single person, he may have had a continuous failure to report income. Again, Ohio, even though the statute seems to allow it, the law clearly does not, the case law, that a series by an individual, even as a public official, doesn't indicate that he's a one-person enterprise. Again, there has to be an association, and this is key, the activities of the association has to be independent of the offense itself. So the idea that someone would go through, well, this person helped them here, and this person helped them here, they're different individuals. They're not all part of the mayor's office. Some of these, we're talking about individual tax violations, or the ones that are limited to, that the jury considered that were out of the mayor's office were kind of minimal. It comes down to, 1, the gambling, and 2, his relationship with Mr. Cafaro, where he waived an ordinance which required that they publicly take bids on it, and he just gave the waiver himself. That's an individual. That's something that he did himself. I don't know of any case under Ohio law or federal law where an individual public office holder engages in bypassing the requirements, the protocol that's an ordinance, that they found that to be an enterprise. Federal court, it's a Hobbs Act violation. They have a specific violation to cover that. But state has something similar, but again, it's violation of a public trust. And more importantly, in sentencing. There's a specific in sentencing that covers that. As the court knows, in the factors for sentencing, one of the factors that can be considered is whether he was a violator of public trust.
I'm sorry, I was trying to allow you, but I had to interrupt. But there's more to that in this case, isn't there? You have allegedly the mayor using public resources, which include individual employees as well.
Well, here's the problem. He was found not guilty of most of those. The briberies, all those things.
What about the theft in office with the medal?
Again, the record doesn't establish this was an ongoing pattern with the same individuals over a period of
Well, there
time.
were more than one episode, and the same individual, I can't think of his name right offhand, was involved in giving the mayor money and so forth.
Yes, again, it's the whole thing of enterprise. Over what period of time is it? This is, Ohio, again, has a specific statute for it, but this was over a relatively short period of time, and then, again, if I'm saying this incorrectly, I apologize, but, when it was brought out, it ceased, it stopped, and this was the benefit to this. The prosecutor alleged the purpose of the enterprise was to benefit his reelection and so that he could become mayor. In this case, where, with the medals, the person who sold the medals, was benefiting himself. This wasn't an enterprise to keep him mayor. This was an enterprise for the greed of the individual along with the medals.
Well, what about the individual employees that took the scrap
again, this is a relatively short period of time, and this is where the activity of the enterprise has to be outside of the pattern of corrupt activity. In other words, the enterprise can't be established by the actual acts that consistent. So if there's nothing in the record that establishes that, you know, that light most favorable to the state, that the court's correct, that there was a series of metal for cash, if that's all the relationship was, that's not an enterprise. Because the enterprise, the evidence that they were doing improperly scrapping metal, that's the only association they had. That may be a conspiracy, but it's not an enterprise.
That's the only association you had.
The only association the mayor had with the people who were doing the improper scrapping.
Well, the company you mean, or the employees? Because the employees were definitely doing other things.
But what in the record establishes a relationship, an enterprise outside of the criminal activity between the mayor and these people? And that's the difference between a conspiracy and a RICO conspiracy. That's the difference between a series of thefts and an enterprise, because there's nothing in the record that establishes that the mayor and these people were part of an organization, not necessarily criminal, but part of an organization. The people who were involved with the scrapping were clearly doing it for themselves to get money. And the argument of the prosecutor is that, okay, that benefited the mayor, but again, a pattern of activity can't be the basis for the enterprise. And that's where this fails, even in light most favorable to the prosecutor.
Could he have been an enterprise unto himself? I guess what I'm saying is, doesn't the law allow an individual to be
No.
an enterprise?
No. The statute appears to read that way, but the problem is the very definition of an enterprise in federal and state law, in ongoing organization with associates, plural, with associates. I don't know how you can be a single individual and be with associates. That function as a continuing unit. And again, we would have to define the plain meaning of the word. A unit involves more than one person. And again, the structure is separate and apart from what caused the activity, and that's why that fails. And that's why I don't know of any Ohio cases, or federal for that matter, that allow a one-person conspiracy.
Counsel, I'm going to stop the clock for just a moment now and let you know that while you said you wanted to also address assignment of error 4, your total time left is 3 minutes and 32 seconds.
I just one more minute to
You can
address.
continue as long as you want, I just want to make sure you're.
No, thank you very much, Jeff.
All right, now I'm going to start the clock and you can.
And in the fourth one, here, this is kind of the problem. In the fourth one, there's a woman who is a forensic auditor from the state auditor's office, clearly an expert, who testified from a spreadsheet prepared by another forensic auditor in which she admittedly stated that he must have been involved in criminal activity because they couldn't trace the deposits. So there was this inference that this may be it. First of all, I think that Judge erred in finding it wasn't expert testimony because she gave the opinion. But even if it was the opinion, the law is very clear that it has to be very concise and very clear, and it can't be conjecture. It has to be based on very solid conjecture. And this is pure conjecture. This is pure, 5 years ago, what's this money from? And he's like, well, my daughter was paying me rent, but I didn't write down every single thing. And then the woman, again, a forensic auditor from the state auditor said, well, my opinion had to be from the gambling because there's no other explanation for the deposits. And again, that's shouldn't have been classified as a lay witness. Even so, her foundation, she didn't even prepare the spreadsheet. She should not have been allowed to testify. Thank you very much.
You'll have 2 minutes and 16 seconds then for rebuttal. And counsel, you'll have 15 minutes.
Thank you. Senior Assistant Ohio Attorney General Dan Caceres on behalf of the state. First of all, thank you for having us here today, sitting in my special assignment. If you'll recall, in 2015, State of Ohio versus Beverly, the Ohio Supreme Court said that the existence of an enterprise sufficient to sustain conviction for engaging in a pattern of corrupt activity can be established without proving the enterprise is a separate is a structure separate and distinct from the pattern of corrupt activity. So everything that appellant just said about having to prove separate and distinct is contrary to Beverly. Ralph Infante for 20 years was involved in a criminal enterprise. The people who were in that criminal enterprise with him, number one was his wife. Number two was Scott Schaefer. He's the employee that you were discussing earlier. Scott Schaefer for 3 years, and it's in our brief, for 3 years went to Metallica, which was a scrap area, a scrap facility. It was outside the city limits of Niles. Made 34 trips to Metallica and gathered $3,292 worth of money. That money went to the defendant, went to the appellant. That's what the trial testimony was. This wasn't a 1 or 2 day thing or a short period of time, as the appellant wants you to believe. It was 3 years. The enterprise had a structure, it had a purpose, and it was long. The structure doesn't have to be, you don't have to have a hierarchy. Boyle said that. You don't have to have professionals involved or professional, something that looks somewhat professional, like you might see on TV. But you do have to have a structure, and we had that here. We had Scott Schaefer bringing scrap metal money to Ralph Infante. We had Brian Perry, Scott Schaefer's boss, getting scrap metal money, giving that scrap metal money to Scott Schaefer, who gave that money to appellant. We have the entire business with the ITAM, the company that the appellant operated for over 20 years. The ITAM had several people who were involved in the gambling operation. You had the wife Judy, you had Denise Danielson. Denise Danielson's deposition that we took of her laid out where Denise identified the handwriting on a number of documents, I think journals, lays out who's involved with the gambling enterprise, the gambling. Every night, Ralph, the money that was taken in from these boards was taken to the Infante house. Ralph Infante controlled the money. Ralph Infante then distributed the money, and then Ralph Infante then kept the difference between what was bet and what was paid out. So you have people who are accepting the money at the ITAM, Denise Danielson, Judy Infante, and Ralph Infante. Then you have people taking that money to Ralph Infante at his home, Ralph Infante keeping that money, and then Ralph Infante distributing that money and keeping $34,000 worth of profit. That's a structure, and that's part of the criminal enterprise. As it relates to Carrie Yoder, I want to dispel some confusion with respect to her. There are 2 auditors here, Carrie Yoder and April Strickland. April Strickland does the master spreadsheet that originally showed $200,000 of unaccounted for cash deposited in the appellant's bank account. Carrie Yoder checks that spreadsheet and goes over that spreadsheet, but April Strickland, who testified at trial, created that spreadsheet. Carrie Yoder does a gambling spreadsheet, 2 different spreadsheets. Carrie Yoder takes the wagers, the wagering on each Super Bowl board. We had the boards, they were filled out in handwriting, and on the sides of the boards, and you've probably seen these boards, the defendant in his handwriting wrote who won and how much they won. Carrie Yoder did what was done in a case in southern Ohio, in the Cincinnati area. A detective in a case called State v. Rhodes. She just added the numbers up. She added the numbers and then subtracted the payout. The difference is profit. It's the same thing that Sergeant Fields did in a case called State v. Rhodes, 2004, Ohio State, 7,000.
Counsel, let me ask you a question
Sure.
about that, because I think now you're going to the assignment of error that your opponent addressed. Secondly, I believe the trial court made some comment like this is nothing but math.
Correct.
And arguably it is, you took in this much, paid out this much.
Correct.
It's that extra. What was the evidence? You even just said it in your argument that, Ralph Infante kept the proceeds of the gambling. Did Ms. Strickland actually opine that the extra was gambling money?
Well, it wasn't Ms. Strickland, it was Carrie Yoder.
Okay, I'm so sorry.
That's okay.
Did the forensic person actually opine that it was gambling money?
Carrie Yoder said that based upon her training experience in the auditor's office, as a forensic audit manager, that it was gambling. There was profit. She did say that. And when you look at it, when you look at these boards and you see how much money is gambled on each board, and you see the winnings that the defendant writes, or the appellant writes on the side of the board, you do the subtraction and you come up with an amount. What else would the amount be?
Okay, so I'm sorry.
No, you go ahead.
So she opined profit, I guess I'm saying, therefore illegal gambling.
She opined
versus
profit.
Your, I don't want to use the word normal, kind of block game that arguably people do all over the place, but there's not profit involved.
The difference between that, the boards that I've done,
I'm not saying the word.
I've done them, I know people that have done them, we used to do them in the County Prosecutor's Office. The difference is, the person running that does not take a cut.
Okay, thank you.
And Carrie Yoder testified that difference, just like Sergeant Fields did in the Rose case, the difference was profit. Now,
Well, counsel, why would you need a forensic accountant to do that then?
that just happens to be her title. She was an auditor assigned to the
But
case.
doesn't that give some kind of extra, if the credibility to her testimony, in other words, if a sergeant, or if anybody comes in and just says, yeah, I did the numbers, and this is what occurred, but when you have a forensic, auditor or forensic accountant that comes in and says, she's lending more credibility to that.
Well, it was it's just her job. I mean, her job is to do the numbers. She was just doing her job. The detective, Chris Rudy, could have testified to that, but she was the person who unfortunately he couldn't do everything. And she was the person who went through the gambling records and did all the and did the math. One comment that was made regarding the city ordinances, and that has to do with the Pegasus deal. Ralph Infante did not waive the city ordinance. What Ralph Infante did was, the city of Niles passed an ordinance authorizing the mayor to go out for bids, just for bids, for a printing contract. What Ralph Infante did was, went out for bids, but then he awarded them. And awarding that bid, he didn't have the authority to award that bid. He didn't have the consent of city council to award that bid, because city council didn't authorize it by ordinance. The testimony was that Ralph Infante that city council members were actually against awarding the bid. And we had 2 city council members testify at trial, and were surprised to find out that, in fact, the Board of Control, which was the board that Ralph Infante, as mayor, was on and ran, actually awarded the bid.
Counsel, what did the city council do about that?
The council didn't do anything about it. What ended up happening was, a year or so later, the company was fired by the service director because they weren't doing the job. You're welcome. So what we have here is we have a criminal enterprise that existed for a long period of time, doing many things. Yes, the tampering with records on the ethics forms, that's something that the defendant himself did. And while we're on the tampering with records, that's one of the assignments of error, and I would call your attention to a case that I indicted, the Judge Birch case, where you had a judge who did not list some property that he owned in Lorraine County on his campaign finance, on his disclosures that he needed to file. And this court upheld his conviction for tampering with records. And what we have here is when we look at the tampering with records, the forms that the appellant filled out specifically states on the form that when you fill it out, list each source of gifts valued at over $75 received by you in your name. And there's a box where you can check it or not check it. He checked the box. So he actually did something. It's not like even the McNeely case, the case that the appellant cites actually is in our favor. But in the McNeely case, the police officer didn't write anything down. Here, the appellant actually took an affirmative step of checking the box.
The box that says he received no gift.
I have received no gifts that I'm required to list, when in fact he was getting $1,000 every December for a period of time from a city employee named Karen DeCristofaro, and was getting other money and other gifts from other city employees and people.
What is your argument as to the court's jurisdiction on the failure to file a federal tax return?
If you look at the tampering with record statute, the tampering with record statutes penalizes as a felon to the third degree when somebody falsifies a federal government record. So the tampering with record statute isn't restrictive. Unlike the drug trafficking statute, I think it says if the federal government prosecutes the transaction, the state can't. The tampering with record statute, specifically within the body of it, allows us to prosecute a federal, for filing a false federal form. Otherwise, that language would be in it. But aside from that, there's no restrictions in that tampering with record statute that specifically says it's for state records only.
About 2 minutes left.
On the final assignment of error, the merger argument that appellant makes, State versus Miranda takes care of that issue. That's well-settled law as well. So again, what we have here is a criminal enterprise that not only that was defendant was involved with for over 20 years, involving a number of people who didn't do things just to benefit them. Scott Schaefer didn't bring the defendant $3,200 of cash just to benefit Scott Schaefer. That money benefited Ralph Infant. Brian Perrodin, when he gave the money, the scrap money, to Scott Schaefer to give to Ralph Infant, that money didn't benefit Brian Perrodin. That money also benefited Ralph Infant. So you have, again, the purpose of the enterprise that was stated in the indictment was to create wealth for Ralph Infant, was to create money for Ralph Infant, and then to hide the source of that money. And the money is hidden when the tax returns and the ethics disclosures are falsified. So it's the state's position that the convictions should be affirmed in their entirety, and I thank you for your time.
Thank you for your argument. Counsel, you'll have 2 minutes and 16 seconds then for rebuttal.
Thank you very much. In the prosecutor's argument, he stated correctly that and I'm referring to the fourth assignment, the forensic auditor. He said that she made the conclusion based on her trained experience. These were the words that came from the appellee, and that's the problem here. That she was a trained auditor and that she came to these conclusions not on her personal observations, which is required by 701, but by her trained experience, which makes her an expert. That's the problem with that, because if she did come under 701, it came out that she, in her report, it wasn't indicated, the breakdown per year over that time, what came out this year, what came out another year. She didn't interview any of the people from the block parties on what they got. She didn't understand there were costs. In those tables, there was nothing that took in the cost, because Mr. Infante argued that, look, this covered the cost. You know, we had a meal, we had drinks, it was all under the cost. That was not in her testimony at all. In fact, she wasn't aware of that and didn't include it.
But she conceded in her
She
testimony
did
that
concede
she
that.
didn't.
Absolutely she did. That's untrue. And she indicated that she couldn't even say for sure who made the transaction, who sent stuff. She just went by the records alone. And again, as the prosecutor said, based on her trained experience. The last thing I want to mention is the prosecutor keeps talking about Scott Schaefer and the, he was acquitted of those counts. He was acquitted of those counts. That's the problem. They're basing this criminal enterprise on acquitted conduct. And that's the problem with the jury instructions it's meant. When you have a jury and, you know, there are these overt acts and they're not, they aren't instructed as what happens if he's acquitted on the main things, which are the briberies. And two of them were thrown out, the rest he was acquitted of. And so we have the prosecutor arguing here that the enterprise is established by acquitted conduct. That's what creates the problems. And based on that, based on the enterprise, we ask that be dismissed, but in the alternative, we would ask on the expert issue that it be remanded for a new trial. Thank you very much.
Thank you as well. I want to thank both of you for excellent arguments on this case. We'll take the matter under advisement and issue a decision in due course. Clerk of Courts will mail you each copy of the decision on the date it's released. Any opinions are also posted on the Supreme Court of Ohio's website.